Today's case is a roller coaster. Glenn Lorenzo White, 62 years old, facing serious charges with a deadly weapon and family violence, finding on the table. The plea bargain caps his punishment at 6 years in prison. But here's where it gets interesting. This isn't his first brush with the law. In fact, Mr. White's record reads like a criminal resume spanning decades. We'll see him try to argue for probation, claiming time served has changed him. But the prosecution, and especially the judge, have his entire past laid out in black and white. And if you think a promise of "I'll never be back" will melt the court's heart, wait until you hear how many second chances he's already burned through. This isn't just a legal decision. It's a test of whether redemption can outweigh reputation. Let's dive in.
For the state of Texas.
Bob Romack for Glenn White.
And are you Mr. White?
Yes, ma'am.
All right, you entered a plea of no contest on May 27th. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. This is to run concurrent with 2025 CC 005111, and there's an affirmative finding of family violence. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, ma'am.
Any objections?
No.
State?
I'm from the state.
No
Defense.
objection.
All right. Any witnesses from either side?
No.
Any witnesses?
None from the state.
All right, then, state. Let me see, I believe you may be opposed. Just one moment.
I was silent, Your Honor.
All right, you're solid. All right, you may be excused.
Thank you, Your Honor.
All right. Counsel, I'll hear your argument.
Judge, Mr. White's had some issues in the past. He said it's different this time. He spent time in jail. It's helped him develop a new outlook. He told me he's going to follow your instructions. If you give him probation, he'll never be back here again. We like the recommendations, the probation, the outpatient treatment, weekly drug testing. He's had a drug problem. He needs to address that.
Mhm.
Also, the 180-day jail sanction is a good idea. We're in agreement with all that.
All right, so, Mr. White, is there anything you want to say?
Yes, ma'am.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record, please.
My name is Glenn Lorenzo White.
All right, what did you want to say?
I was saying I made a mistake in my life when I lost control.
This is the classic defense pitch. Frame the client as someone at a turning point, fresh perspective from jail time, ready for rehab, willing to follow strict conditions. On paper, it sounds reasonable. Probation, outpatient treatment, weekly drug tests, even a 180-day jail sanction if he slips. But remember, probation is a privilege, not a right. It's the court saying, "We trust you enough to stay out of prison." The million-dollar question, with Mr. White's history, can the court trust him? If you were the judge here, would you risk it or lock in prison time?
All right, so here's the thing. Are these mistakes or are these choices?
No, it was really a mistake.
Why do you say it's a mistake?
Because I don't know, I just lost it at that moment.
Well, no,
I got really angry and stuff.
no, here's the thing. You picked up a hatchet, right?
It was tomahawk.
Okay, you picked up 2 tomahawks. Did you think it was something else? Or did you know it was a tomahawk?
No, it was tomahawks. I just grabbed them when I wasn't thinking.
All right, so you grab 2 tomahawks. And according to this, it's with this Monique Gant,
Yes.
someone that you've used drugs with. I don't know why you all are still together because I've read the PSI report and you have 2 children, younger children. You don't even know where they are because you were using drugs. She was using drugs. You didn't get your life together with CPS and your rights ended up being terminated. And
Here's where the story turns from vague to vivid. The judge reads from the victim's account: 2 tomahawks, a pole smashing through a taped-up car window, a verbal threat within 5 feet of the victim. Mr. White admits to tearing plastic from the window and grabbing the weapons, but claims intoxication clouded his judgment. Legally, that's no excuse. Intoxication doesn't erase intent in a violent act. This moment is crucial because it reframes the case. We're no longer in mistake territory. This is about deliberate, dangerous conduct.
Victim stated that suspect, that's you, arrived at the location to charge his car battery. Suspect saw victim's car and went inside the house to take groceries that the victim bought. Suspect put 2 hatchets on victim's car. Suspect then grabbed a pole that was on the ground and tore through victim's taped up window and attempted to grab things from her vehicle. Suspect then grabbed the 2 hatchets and was swinging them around, approaching victim, coming within 5 feet of victim. Victim stated that suspect said, "I'm going to cut this bee," and noticed witness standing behind her. Victim stated that suspect walked to the neighbor's house and dropped off the 2 hatchets at the neighbor's house.
That is not true. I went to my mom's house. That was my mom's house.
So why would you try to take groceries from the vehicle?
I didn't take no groceries from the vehicle.
Well, I mean, she said you cut through her window. I'm assuming the window was.
No, I picked up the little pipe thing and it had plastic on the window and everything. I tore it off.
And here comes the knockout punch, the criminal record. Assaults, thefts, drug charges, criminal mischief, probation revocations, parole violations, stretching back to the 1980s. The sheer length and variety of offenses matter here, because sentencing isn't just about this crime, it's about patterns. The judge is making it clear. This isn't a one-off bad decision. This is a lifetime of run-ins with the law. In the world of sentencing, history isn't just background. It's a predictor.
I don't think you'll be a good candidate for probation. And let me just tell you why. You've been on probation before. Then you have a theft case that you were convicted of. Then you have a criminal mischief that you were convicted of. Then you have an assault case that you were convicted of. This started in the 80s. And then you have another criminal mischief that you were convicted of. Then you have another assault case, they say dismissed for insufficient evidence. It's probably dismissed because the complainant didn't want to go forward with it. Then you had a possession of marijuana, and I realized it's marijuana, but you were placed on probation for that, and your probation was revoked. Then you had another assault, and now we're in the 2010s. You had another assault, and you were given probation, and your probation was revoked. Then now you have a violation of bond or protective order, which I'm assuming is related somehow to this incident. Then you had an aggravated robbery case that was rejected. I'm not even considering that because it's rejected. I don't know why it was rejected. Then you had dealing cocaine. You were sentenced to state jail facility. Then you had another dealing cocaine and you were sentenced to prison. Then you had a burglary with intent to commit theft by force, and you received 15 years for that. And then you had another manufacturing delivering. You did time for that. Then you had an aggravated robbery. It was dismissed for missing witness, injury to the elderly, dismissed, missing witness. And now you're here before me. How old are you?
I'm going to be 62 years old.
All right. So I don't think you're a good candidate for probation.
Can I say something?
Sure.
See, I've changed my life. My mom got sick now. I'm old too.
This is a human moment. Mr. White says his 80-something mother is all he has left, and she's in poor health. He worries she might pass away if he's in prison. Emotional appeals like this can and do sway judges sometimes. But here, the judge points out the hard truth. He knew about his mother before the incident and still chose actions that landed him here. It's a reminder that personal hardship doesn't erase responsibility, and that sometimes sympathy runs headfirst into public safety concerns.
So here's my question for you, and I'm not trying to be cruel, but you knew about your mom. Why would you do this, knowing about your mom?
Well, my mom just got sick recently. since I've been locked up.
Hmm.
This shit started since I got locked up. She's been in the hospital in and out about 4 or 5 times. They had a minor heart attack.
Yeah.
I didn't think it was gonna be like this.
Well, I mean, these are things we need to consider, right?
Yes, ma'am.
All right, this is what the court is going to do. The court is finding you guilty. There's an affirmative finding of deadly weapon, affirmative finding of family violence. The court will sentence you to 5 years in the prison.
And there it is, 5 years in prison with credit for time served concurrent with another case. Affirmative findings for deadly weapon and family violence, both of which carry serious legal consequences, including a lifetime ban on owning firearms or ammunition. The judge also bans contact with the victim and recommends the therapeutic community program in prison. That's important, because while she's denying probation, she's still leaving a door open for rehabilitation. In sentencing terms, that's a firm but hopeful approach.
I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, we can go off the record. Here's the thing, Mr. White. Your history doesn't look good, right? And sometimes I look at that, right? And I have to look at that because I have to consider everything. And so I'm looking at your history, and your offense is escalated. And then you have different issues where you are placed on probation, your probation gets revoked. You're given parole, you don't do well on parole. And I will tell you, I've done parole hearings before, and parole is so much easier than probation is. Because parole is sort of, in a way, it's sort of like college. And this is the best way I can explain it. When you're in public school and you're not in college yet, everybody is telling you everything to do. This is your class for today. That's what probation does. When you get on parole, what they do is they don't tell you you need to do this, this, and this. They just give you a sheet of paper. You have your freedom. And on parole, if you report, call them whenever they want you to call and do a drug test and get employment, they're happy. They're satisfied. So for you to have the parole issues that you've had, that tells me a lot. But I'm recommending the therapeutic community for you. The therapeutic community will help you when your parole time comes up, because they're going to see that you are actually doing something to try to help you with your drug addiction. Because when people are looking at whether or not to place you on parole, and I've done parole packets for my clients in the past too, they want to know if they place you on parole, is this a person who's not going to commit any more offenses? So you need to be working on a plan. Like, I'm going to be doing sober support meetings. This is where I'm going to be doing them. This is where I'm going to be living. I'm going to be stable. This is how I'm showing you that I'm going to.
So here's the big takeaway. Glenn White's decades-long criminal history, combined with a violent new offense, outweighed his plea for probation. The judge stuck to the plea cap, 5 years, but layered on restrictions and a rehab recommendation, signaling this as both punishment and a final chance to turn it around before parole boards take over. This case is a study in how a defendant's past can overshadow even sincere-sounding promises of change. In court, your history speaks louder than your words. If you found this breakdown eye-opening, hit that like button, drop your thoughts in the comments. Would you have given probation here? And don't forget to subscribe for more real-life courtroom stories that pull back the curtain on justice in action.